Right. Good morning, everyone. Thank you so much for joining us this morning at our IRR media or press briefing. It's going to be a bit different this morning.
Right. Good morning,
we
everyone.
are joined by
so much for
perhaps the notorious but certainly impressive Advocate Erin-Dianne Richards, who has been really one of the leading voices in the fight surrounding the legality and the law as related to COVID-19 and the lockdown. And we are really, really privileged to have her here this morning. We will be having a conversation where we thought it might be the best format to explore these issues in depth rather than perhaps presentation or prepared remarks, to really keep it alive. So roughly how this should work if all goes well. Firstly, I should perhaps introduce myself. I'm Herman Pretorius. I'm the Deputy Head of Policy Research at the Institute of Race Relations. So I will be controlling this morning's discussion and having it with Erin-Dianne, in fact. So there will be a conversation of roughly 20 to 30 minutes, depending on how interesting I manage to make it. But I will try my utmost. Thereafter, we will definitely go to questions. We will go to questions from journalists who are in the call. If you are listening on YouTube, if you are following our conversation on YouTube and you have questions and you are not a journalist, please tweet those at us. I have colleagues of mine on standby to direct those questions to me. Please tweet them either at the IRR or use the hashtag Keep Liberty Alive, hashtag Keep Liberty Alive. So with those formalities out of the way, it gives me great pleasure to say good morning to Advocate Richards. Erin-Dianne, very good morning to you.
Morning, Hadman. Thank you very much. It's so lovely to be here. I'm looking forward to the chat. But I heard your subtle insinuation that if it's under 20 minutes, that means I'm not entertaining. So let's go.
No. But believe me, I think my colleagues would attest to the fact that the error would be all mine. So you have made a significant issue in these last few weeks, specifically on this body that the president has referred to and that we see the Minister of Basic Education referring to again yesterday, the National Coronavirus Command Council. Now, perhaps the first question I need to ask you is, why did this pique your interest?
Hadman, I wish that I could tell you how many people have asked me that question. And the honest answer is I'm not sure what piqued the interest. I know when it was piqued, and it was piqued the first time I heard it, which was at the president's initial address, where his words were, "We have established a national command council." And I just thought, that to me, maybe it's because of my political or ideological leanings, that it just carried a tone to it that I was uncomfortable with. And I have one of those brains where things must make sense, especially at a governance level. I like to know how things are being run, because as a lawyer, I can't check things. I can't scrutinize things if I don't know the process that they're following to make decisions. So that's when I started looking for any sort of statutory basis for this command council. And that's when the inquiry began. And honestly, I thought it had somewhat disappeared. Until it was rebirthed yesterday, and now making decisions together with the cabinet, whatever that means. So yeah, that's the introduction.
Now, why should ordinary South Africans be concerned about this command council? There is perhaps a good case to be made to say that it's an interesting legal issue, it's an interesting constitutional issue. But I think quite often people might think, what's up with the lawyers lawyering about when the country is facing a real crisis?
Yes, and it's a somewhat circular answer, because the reason is this. Just assume that the following is correct. So let's assume that the Command Council is a concentration of 17 ministers. And let's assume that what they've told us is correct, that they are making all the biggest decisions in the country. Let's also assume that because it is such a concentrated body, Parliament can't exercise oversight over it. So what does that mean, Herman? It means that there are 17 or 19, however many there are, ministers calling the shots and running the country on behalf of 60 million people. That's not academic. And you've also got to realize that when there's an unchecked concentration of power, you can't properly scrutinize the rationality for these decisions. So if it was working properly and there was proper oversight and proper scrutiny, we would still have had a lockdown, but we may have had a more rational lockdown. We may have had a less damaging lockdown. So there are all those considerations, and this is why lawfulness matters. It's why the Constitution matters. And I understand that, a lot of people look at this. It's like, what I do with finance, people investment. I go, okay, that's nice. I'm sure it's important, but I don't understand the lingo, so I don't go there. It's the same thing, I think, with law. The bigger problem is a situation like this. You really need to understand how the country's governed to understand the ramifications of what's possibly gone wrong.
Yeah, that's so the oversight point you make, I think is very interesting, because surely if we are going to be a constitutional democracy, then we have very strong oversight mechanisms. So is your fundamental point of critique that this weakens liberal democracy, or at least it weakens the ability to keep power in check?
Yeah, I think my concerns are twofold. The first is an abuse of power, which just seems to me to be absolutely rampant, and it seems to be manifesting at pretty much every angle. So that's my first concern. And obviously, our Constitution gives us a way to manage that abuse, which is supposed to be Parliament. But Parliament is used to overseeing the executive, not some other body that's half the executive, sort of the executive, who knows. Okay, so there is definitely a compromise in oversight, which John Steenhuisen flagged right at the beginning, and the DA is now taking to court to some extent. So yeah, my concern is definitely one that the entire liberal democracy as we've built it is in jeopardy. And I'm not sure how we got to a point like this, where our country was devastated over a period of 8 weeks, and Parliament failed to conduct its oversight role. And if that oversight role was compromised, it failed to go to court to protect its oversight role. Why is it 8 weeks down the line, when the country's been losing billions every day? Why has it taken this long for us to get anywhere? That is a very fundamental governance question that I have.
Now, perhaps we should make clear at this point that from statements you've made, from interviews you've given, and from discussions we've had, it's quite clear that you're not sparing your criticism for government. This isn't a political move for you. You don't think here's an opportunity to score some points for the DA, for the ANC. In fact, you've had some harsh words all around.
Yeah. I think there's a couple of points there. First off, I've always been skeptical of politicians. The manner in which politicians in general have handled this crisis has wiped out any respect or hope that I have for them as a general establishment. I think the way current politics is practiced is actually harmful to democracy. I don't think it's politics in the true sense of the word. And I think that as citizens, we have just surrendered our agency to politicians, and I think it's a problem. And I'm not just critical of, while I'm concerned with what's going on in the executive, I'm also critical of how our leading politicians conduct themselves, and that goes across the board. I'm not one of these people who believe that you must only scrutinize the majority party because the other guys will worry about them when they get there. That to me is rubbish, because a party forms while it's waiting in the wings. What it can get away with when it's waiting in the wings will amplify when it's in power. So it's equally important, I think, for us to police and keep an eye on our opposition parties as well.
Now, this disempowerment that you speak, this surrendering of agency, surrendering of power. I find that a very interesting point that you've made on a few occasions. Perhaps I should ask you, what do you, a two-part question, what do you mean by that? And secondly, isn't it right for a country in a crisis to surrender some of its agency to deal with a crisis like this?
So what I mean by having handed over our agency is that, and this is not something that's specific to this disaster. This to me seems to be something that we as South Africans have done right from the inception of democracy. And let me speak about it from that perspective. It's almost as though we landed up with a constitution and the general South African citizenry went, okay, this is nice, the hard work's done, we've got this piece of paper and it will protect us. But there's a link here between the constitution and society. The constitution can protect society, but society's also got to protect its constitution. Okay. And that's what we haven't done as a society. We haven't protected that constitution. And I don't mean by that we haven't gone to court, etc., because of course we have. But we haven't protected it by arming ourselves with knowledge. Now, let me give you an example, arming each other with knowledge. Let me give you an example. You go and you ask any random person, say someone who's got 1 or 2 degrees, what is a cabinet cluster? Or you ask them, what is an interministerial committee? Or you say, what's the difference between the two? Or you say, what is the Presidential Coordinating Council? These are not up in the air fluffy terms. They become important because, for example, when we sent this letter to the president and their response was, it's a cabinet cluster and it coordinates, I could immediately write that off as being rubbish because I know what a cabinet cluster is. You know, but other people will be persuaded by that because it seems like a rational justification. So this is what I mean by having surrendered it. We have not empowered ourselves with knowledge, and as a result, we've given up our agency because you can't exercise agency if you don't have knowledge. Does that make sense?
Yes, it makes a terrifying amount of sense. When you mentioned this letter, and that's actually something I want to get onto. It's unusual for advocates to take up that role that you and your colleague did by becoming, as it were, clients of attorneys and them sending on your behalf this letter. Why? Two questions. Why did you take that step? I think you've been asked that question ad nauseum, so apologies, but I think it is an important one. Why did you take that step? And secondly, did the government respond, or the presidency respond, in the way that you expected it to?
All right, so first I forgot to answer your other questions. I'm going to go back one. You said, is it normal or expected for people to surrender their agency in a crisis? And my answer would be probably yes, to a certain extent, but subject to them doing so knowingly. So knowing what they're giving up. So we know that the country is normally governed like this. We give up that scope for now because we're in a crisis. All right, so first, so again, everything for me comes back to this threshold of knowledge. Okay, then why did we take the step? Let me say this. The letter has quite a long history. The letter went out on the 27th of April. By that stage, I had been researching and thinking and talking to colleagues, etc., for over 6 weeks. Okay, so it wasn't something where we woke up one morning and said, hey, let's write a letter. Because Nazeer and I are advocates, we did not want to step into that role. We didn't want to. So we tried to alert clients, we tried to alert NGOs, we tried to alert political leaders, we tried to alert MPs. And when I say tried, I mean on a daily basis. And only when that failed, were we so concerned about the fact that no one was debating how the country was being governed, so concerned that that debate was dead, that we said, well, fine, we will write the letter and professionally come what may, just bar us, do whatever, but we're going. So that's it. It was that dark cloud that was over civic debate at the time that actually propelled us into action. So as much as our concern was about the command council, even more than that, we wanted to try and just reinvigorate that debate, get it going, which I think, at the very least we succeeded in doing. So we're happy with that.
And congratulations on that. I do think that you ought to be commended for reinvigorating this debate to a significant degree. I mean, here we are talking about it in front of hopefully a relatively large audience and the friends of the IRR, the thousands of people who make it possible for us to continue doing, for me at least, to continue doing my job.
Yeah, you guys are great.
Thank you very much. The mutual respect will probably be sickening if we indulge it too much. So to stick to putting the hard questions to you. And I see you've not answered my other question.
Oh, so which was that?
It was the response from the presidency. Expected, or to use a phrase that someone famous in our country might have used, were you shocked?
Yes, I was shocked, and the response invoked the ire of my entire profession. I was receiving calls from very senior members of my profession saying to me, it's absolutely outrageous. Basically, it was tongue-in-cheek, it was sarcastic, it provided no answers. It basically called us unprofessional and was an attempt, we feel, to try and invoke the profession into disciplining us or disbarring us. So it was a complete attempt, as I viewed it, to, excuse my language, shut us up, either by embarrassing us or whatever the plan was. Thankfully, our profession just came out in mass support to just say, this is not how this goes down. We have two members who respectfully engaged with you. You do not respond like this. And they basically just from a professional perspective said the fact that these people are officers of the court has nothing to do with it. They're acting here as citizens. Answer the questions. And we didn't get answers to questions. We did have a meeting with the presidency, which consisted of, and this was the day after the president's last speech, where everyone was hoping for news on the command council. We did have a meeting with the presidency, with Dr. Lubisi and with Advocate Jele, who is the president's very able advisor, as I understand the situation. And I did not get one concrete answer to a single question I asked in a 1 hour and 6 minute conversation. So there are still no clear answers, is the position, according to me.
Now, I think that is also my understanding of it. And as you pointed out earlier, it was intriguing that the National Coronavirus Command Council as a concept almost fell out of use systematically from the point where you flagged these issues, and then pops up yesterday again, not in any ambiguous way, but clearly stated by the Minister of Basic Education that the Command Council decided. I mean, it clearly, the Basic Minister thinks that this body has decision-making power.
Well, I mean, let me just put this into a chronology for you, because what actually happened, if you look at the chronology of what was said before our letter, you have 39 days of very clear communication from the president, that it also appears in policy documents and in presentations that the Command Council takes decisions. Very straightforward. That's it. Then the letter gets raised and all of a sudden, no, now it's a coordinating body. Oh no, actually, sorry, it's not really a coordinating body. It also takes decisions, but it does so with cabinet in a way that it assists cabinet without taking a decision. I mean, it just, no. So I think what's happening now is that there might be some kind of communications attempt to stabilize the narrative, to try and make, say, the approach might be, oh, well, if we say cabinet and we say command council together, it sounds a little bit more legitimate. I think what happened, my personal opinion, is that there might have been an oversight right at the beginning, and it's just now one of those things where there's political trouble brewing, and you've got to try and normalize the narrative. And I wouldn't be surprised if that's what's going on. But who knows? There might actually be a rational explanation for this, but we might only see that in court papers. That's just how it works.
Yes. Now, oversight. You say this might have been an oversight at the beginning. From my time in politics and political analysis and so on, it seems to me that never ascribe the rule, never ascribe to maliciousness something that could be ascribed to incompetence. Now, that might be a very charitable view of the situation. Would you say this is closer to maliciousness or incompetence, or does that question actually put you in a difficult position going forward?
No, it doesn't. And I mean, I'll answer this with reference to, if you'll just excuse me, I'm just looking at my cell phone because I sent you a presentation yesterday, Herman. And this is a presentation that was downloaded directly from the COGTA website. It's called COVID-19 Presentation to Cabinet, and it's dated 20 April. And what it says is that COVID, and you can send this on to anyone who wants, you've got it there. It says, COVID presents an opportunity for South Africa to accelerate the implementation of some long agreed upon structural changes to enable reconstruction and growth. So this tells you it's not only about a virus, but the ANC has this is not surprising because the ANC and I think all political parties are deeply steeped in ideology. So I think it's politically natural for people to capitalize on a crisis to try and cement that ideology. I don't know if that goes to the level of being malicious. It goes to the level of being an effective politician, arguably, for your constituents. As for whether that is ethical, under these circumstances, my answer would be no. But I wouldn't ascribe it to maliciousness. I think it's an opportunity to cement ideologies, and that's probably what's happening.
So if we're going to look at we've looked quite in detail at this command council, and perhaps if we take a step back further to view the lockdown regulations as a whole, my suspicion is that we're going to see liters and liters of ink spilled over coming months and years on litigation, in legal journals, hopefully in more than legal journals, things that people actually read, on the legality issues here, and I think specifically perhaps the rule of law. Do you think that's a correct anticipation? What's your view of what the legal fraternity going forward will make of this?
I am definitely hopeful that will happen. I'm a massive advocate, and obviously in a different sense, for that. I will certainly be making an effort to write out about that, and not so much about rights, but about government, about how governance works. And there have been a couple of questions about whether this should sort of spread into school education. Just the basics. Just here's the Constitution, here are your rights, here's some, put it in the the history section or something. And I think that there's definitely something to that. I have not found all that much appetite amongst my colleagues. Lawyers are I'm convinced the majority of us are severe introverts. I am one of them, but a lot are worse than me. So this notion of we're not educators, we're not explainers, we're arguers and fighters. So we have a slightly different personal narrative about us. So I'm very keen. I'm looking at avenues to do that, and I think it's fundamentally important, and that's my hope. And my hope actually is that lawyers, when they do find the time to write, do it less in legal journals and more in the public domain. It doesn't become less useful to lawyers because it's in the public domain and it's in accessible language. It just means that you're helping to educate other people while you're learning yourself. So
if we were to look at the education, of people generally in terms of legality, then the rule of law is surely. Let me just quickly mute one of our attendees. The legality of these matters relate very closely to this abstract and sometimes fuzzy and sometimes even perceived as antiquated idea of the rule of law. Because surely, if we're going to have the rule of law, one of the elements, as the Constitutional Court has itself found, is that laws, regulations, legislation can't be vague. Have we just ran slap bang into a wall of legal vagueness?
Yeah, it seems to me that, and this is always a very interesting conversation that I hear between colleagues, informally when we do our WhatsApping these days, because no one sees each other. But this is definitely a question that's coming up, as people are saying, these regulations are vague. But the question is always, do you attack one regulation or do you try and attack all the regulations? And attacking all, although they're all vague, some of them will have less vagueness and more irrationality, and some of them it'll be vice versa, or some of them will have process irregularities. So to try and do it as a whole becomes difficult, but then when lawyers look at doing it individually, it's just so overwhelming because you've not only got the regulations, you've got directions being issued all over the place. And so you've got to look at those as well. So it becomes very overwhelming, and it does appear to me that just wherever I look, there's so much uncertainty in the law that there's no doubt that it's hit by vagueness. But the only question is, how do you effectively deal with that? And like my colleague Mark Oppenheimer would always say, there are certain people who do certain things. Everyone has their roles. So, mine is more governance focused. And then there would be those who are strategically picking the best individual regs to go for. The ones that if you win, A, the ones that are more winnable, and B, if you win those, people are going to be more free the next day. That's the strategy.
Now, this requires litigation, or it requires the involvement of the courts, the judiciary. As an advocate of the High Court, aren't you worried that we might be embarking on an avenue of governance by courts? Because if we're going to be concerned about democracy on the one hand, then surely governance through the judicial bench is also a problem.
Yes, and I have a very bad habit of buying books for people, and you've got a lot of these coming your way. Okay, so it's all about government by judiciary.
I do see the Institute of Race Relations survey there at the very top left. Yes. So I'm glad to see.
From when I first met France, and he wrote me off as being nuts. So yeah. So look, there is a very good book where a term juristocracy is coined. And that to me is very important. And we see our Chief Justice has before said, we are not a judiocracy. And I think what he meant is juristocracy. I think it was he meant to take that word out of the book and then got it a bit wrong, as we sometimes do. Now, we're in a very unique situation in South Africa. What you're talking about is the separation of powers. Court must stay in its lane, okay? It mustn't infringe on executive power or on legislative power. All the court must do is apply the law. The problem is that we have a constitution that expressly makes the constitutional court the guardian of our democracy, okay? So in my view, it is impossible for the Constitutional Court to be the guardian of a democracy and then always have to stay out of the political lane. If you read more recent judgments like the Nkandla judgment, the point is made there that the Constitutional Court is specifically designed to deal with more political issues, okay? And that's what the Constitutional Court has actually, in fact, been doing throughout its existence, but it does so carefully. the easiest way I can explain it is when there's some kind of democratic breakdown, the Court will intervene there, and then it will retract, and it will say, here's a lawfulness issue, go fix this however you want, but here's the issue. Okay. Sometimes it does go a little bit too far, but I personally am not overly concerned about that, because to my mind, the Constitutional Court has been largely responsible. You know, and you will see some more progressive benches and some less progressive benches. But a lot of what happens in the Constitutional Court is also brought on by advocates, because we are the ones as practitioners who advise our clients on what cases to bring. So as things change, you know, we will change the kinds of cases we bring before the Court. So there will be different phases, and that court will grow more into its role. And so far, I'm encouraged by what it's doing. And I feel, especially in this time, we can be very, very, very grateful for some of those more progressive judgments, because when citizens do need to go to the Court and they do need that court's help, those judgments, those progressive judgments that a lot of people complain about, will be the ones that cloak them in success.
So on the role of the courts, two questions. Do you think that the recent judgment by Judge Fabricius on the death of Collins Causa and the consequences for members of the Sundef forces, do you view that as something that should be emulated, that kind of approach where the courts perhaps do not make big governance calls, but they make accountability calls? And then second question that I have for you that might be testing your previous answer is, what do you make of the Constitutional Court's refusal to grant, I think, leave to appeal on the matter of the tourism minister's insistence on race-based policies being used for governmental assistance?
Yeah. Yes. First question on the Causa judgment. I mean, that case was spectacular. That's actually usually because the matter is important, and you need the views of more judges and of more courts. So, and as someone who really cares about their case, especially if that case is very complicated, it is often useful to go through the channels so that you get the views of the judges on the lower courts, you get the view of the full bench, you get the view of the SCA if you go there, and then the Court has got the facts, it's got the case, and it's got the views of all of its judicial colleagues, and it actually helps the judicial making process, rather than just having a bench. And they're a brilliant, very competent, very well educated bench, but they are limited in their number. You know, so there is a very good rationale for sometimes forcing a matter to go through the processes, and you can go through those processes on expedited timeframes if necessary. You know, so the court's just saying, go through the process, come back to us when there's more voices. You know, and I was actually very concerned. There was a period where, you know, some political parties were in the Constitutional Court on direct access or exclusive jurisdiction like every second week. And I couldn't believe what I was seeing. That to me was worrying, because there were a lot of those cases that, to my mind, should have gone through this whole process. So I'm actually glad for a slightly more conservative process. And the same goes for Collins Causa. You know, they also chucked that one out on, I think they went on interest of justice, and Concord said, go back to High Court, and they went. So I'm okay with that. I don't find it worrying.
So to get back to your point of education, it seems to me that we have two educational voids in South Africa, as it were. One, constitutional and governmental, and two, legal and judicial. People here, constitutional court does not allow argument of case before it. It says go to the Supreme Court of Appeal, perhaps, or go to a different bench, and they immediately assume, therefore, political decision by court, country down the drain. So on the one hand, if we were to embark on an effort to get this judicial understanding of the judicial process going, does that overlap in your mind, to a significant degree with the constitutional education that you also think is lacking when it comes to matters of governance?
Yeah, I think that it's important, and I don't see a rationale for separating the two. I think that the two dovetail very well together, In fact, I think that there's three sort of distinct but interrelated aspects. The one is, and we've done quite well as a society here, canvassing your rights. So people generally know what their rights are. Okay, so there's that. Then there's the second thing of understand how the government works. Okay, little internal mechanisms. And when you say oversight, how does that actually happen? So let's give people a picture with which to work. And then the second is what you say is, how does the judicial process actually work, and what is its role? Because we see a lot of public debate about courts overstepping, courts not doing this, but that's underpinned by a lot of confusion about what we actually do. And it's not like as lawyers we're 100% clear on this either. The Constitutional Court has said to us that South Africa has its own unique version of the separation of powers, but does not go on to explain to us exactly what this unique version is. So we know that we have it, but we're not sure exactly how it works. So we're working it out as we go, which is fine, as long as we don't land up with some sort of massive judicial overstep while we're at it, which I don't think has happened.
Two final questions from me before I throw it open to our press colleagues. Firstly, you, over a very short period, became a banner carrier for many people in this country fighting governmental overreach, the powers that be, the status quo, call it what you will. But then you announced that you are stepping into a different role. And I saw it was quite frustrating for you that people saw this as some form of surrender. Could you perhaps address that? Because I think it would be fair of me to give you that opportunity to say, what did happen, what did not happen.
Yeah. So it's more about, and I think what's disturbed me most are the accusations of corruption. Like, people are assuming I was paid off when that is just not factually even close. I mean, I received nothing. But I suppose that's a character assessment. If people don't know you, they're going to make assumptions. So, I let that lie. As for this thing of I backed off, I most certainly did not back off. I have stepped into a different role. Nazeer and I, as I said, it's extraordinary for advocates to step out of their roles. And they are only allowed to do that. They're only permitted to do that in extraordinary circumstances. The extraordinary circumstance was the death of civil dialogue. Okay, so we intervened, but then civil dialogue reinvigorated itself. And we said, okay, that's fine. Let civil society carry it forward. They will go to court on issues that they feel are important. That's how democracy works. Nazeer and I are both constitutionalists, and we are very protective of our profession and of democratic boundaries. So when we intervened, democracy was just not working in our view, because there was no dialogue. People didn't have the guts to stand up to government. So we said, here we go, here's an example. And then when that dialogue reinvigorated itself, that extraordinary circumstance that necessitated our engagement was no longer there. So we withdrew. in that role and in that perspective. And just think about it rationally, because if we had taken the thing to court, it would have been 2 advocates. We would have had to draft the most diplomatic papers in the history of the world, okay, just because it's of its sensitivity. So it's not smart. If citizens go, they can ask for broader relief. The court will not pussyfoot around them, so that they're free of those sort of internal, I don't know, ethical and just minefields, okay? And it's more powerful. That was our point all along, is civil society needs to do this. Stop delegating to politicians, stop delegating to other people. And now they're doing it. That is a good thing. So I don't see why people are freaking out about mine and Nazeer's stepping back. They should have freaked out about our stepping in, so the whole thing is the other way around. But time will tell, and I will let people's views and judgments unfold over that time.
Excellent. And last question from me. You mentioned at the beginning and now also this delegating of power, this giving up of power. Not to make too great of a play on your nickname, but how do we claw back the rights, the liberties that we've lost?
I think it's twofold. I think the education element that we've spoken about is probably the most important, because I don't think that our generation can claw it back. We'll get it back to a certain extent, but I think for us, the ship has pretty much sailed to a large extent. It's about asking ourselves, how do we create a different world where someone who's born 30 years from now knows how to manage his or her rights and his or her agency as a citizen. So that's where I'm thinking, because I'm not sure we're going to make massive progress, before I expire. So, I think that's the point. And then as for the immediate plan, I think we need civil society, NGOs, people, pro bono litigants, whoever, in court. We need to depoliticize the issue. We need to get away from this DA fighting ANC in court nonsense. It needs to become more grassroots and more generic and done through the NGOs. And if we can do that, I think we will stand a chance of, and fight through the courts that way. I think then we'll stand a chance.
Thank you very much. Now I am going to throw this open to questions primarily from our media colleagues. Any journalist, if you would like to ask a question, please move your mouse over the screen. The bar, if I'm on your screen, should be about here, where there will be a hang up button to the right of the bar. I hesitate to say the far right, but it's there. Then you can move over to the speech bubble, 2 buttons to the left of it. Click on that and you will find the chat function of this conversation. If you have a question, you don't have to type the question there. Please just alert me to the fact that you have a question. Then we can go to you, I can identify you, you can unmute your mic, and you can put a question to Advocate Richards. So while people might be typing or busy figuring out from their notes from the discussion whether they want to ask a question, please type. So now I'm going to ask just a bridge question that I didn't plan on asking now, but it follows up on what you just said. You want civil society to become involved. How does that look practically? Because I think many South Africans have this idea that, they would like to do something. They would like to become involved in what we at the IRR call the battle of ideas. And we certainly have some very specific ideas as to how you enter the fray, how you as a citizen become involved. But from your perspective, what would your advice be?
I think that a lot of it, like I said, is going to come from your NGO sector, places like Dear SA. There'll be a lot of mobilization there. What I'm also seeing are a lot of associations being formed, so like associations of epidemiologists, associations of lawyers, associations of doctors. And I think that's the beginning of it, is that people are coming together to say, look, this is our community and these are the problems that we have. They then form associations and they take legal advice, and eventually some of those will sprout into legal action. You know, I have received huge amounts of calls just alerting me to this thing where people are forming associations, and I think that that's great. I certainly have never heard of this many being formulated. Maybe it's just that now I'm being kept in the loop and it's always happened. But I think that kind of generic movement is really good. And I think that there should be a lot of media coverage of that. You know, this is also a problem, is that the media, to me, covers stories to sensationalize them. And I'm talking mainstream media here. And this issue with my colleague, I think it was yesterday or the day before, is an example. Rather than dealing with the substance of the issue. So I think there needs to be, you know, just a growing voice in the media that gives civil society a voice, rather than giving people with power voices.
We have a very good question from one of our YouTube viewers with specific regard to the Disaster Management Act, where the phrase "own resources" is used. What do you make of? I'm not quite sure what this questioner might be referring to, but perhaps you are. If you are, what do you make of the definition of own resources in the Act?
Yeah, I think where the question is going is to say that, you know, the Disaster Management Act can only be invoked if there's a disaster that we can't deal with using our own resources. And, you know, some people would say, but we can deal with it with our own resources. You know, it's a virus. We're all happy to take our chances. And so what's the basis for having invoked this thing in the first place? You know, and these kinds of questions I tend to shy away from, because I think that they're underpinned by a knowledge of science and the data. You know, you can say, to my mind, to ask whether or not we can deal with it with our own resources means I must know what it is. And at the moment, all my government's told me is that it's a virus. I don't have access to source data. I've only got access to government data, which I don't really buy into, in all honesty. And I've only seen some models. So, you know, based on only what I've seen, I can understand why people are saying, but we could have dealt with this on our own. You know, we didn't need additional resource. We didn't need state intervention. So I hear the substance of the complaint, but to me, I cannot answer questions like that without, as I say, knowing the source data on which we're currently all locked down or whatever we're doing.
Right, I have another question from YouTube, which is actually, again, a very good question, is the issue of a state of disaster versus a state of emergency. Perhaps you can touch for our viewers on the difference between the two as you see it, the most important differentiation you see, and also perhaps we should consider why the government has gone for a state of disaster rather than a state of emergency.
Right. So there is an important difference, but I think that there are actually three states that people need to be aware of. There is a state of disaster, which is what we're under now, which is where there is either a provincial disaster or a national disaster. The state can take measures to curb the spread or to curb that disaster. Okay. Now, the Act is very broad in its terms. It doesn't include a provision about parliamentary oversight, but it also doesn't exclude the provision. So you'd have to interpret the Act to work out what it allows for and what it doesn't. My reading of the Act is that it actually gives relatively narrow powers on a proper interpretation. Those powers have just been abused. Okay. Then you have a state of emergency. A state of emergency is like the next scale up. Okay. So that's where, and a health crisis, etc., could also fall under state of emergency. But the Constitution sets a second requirement for states of emergency, and that is that it must be necessary to restore peace and order to the Republic. Okay, so where you must have lost peace and order, which is like people protesting all over the streets or whatever. There must be a loss of peace and order before you can invoke states of emergency. States of emergency makes very strict provisions for parliamentary oversight, and a state of emergency can only last for 21 days, and then Parliament has to approve its extension. Okay, so it's got very strict parameters. I hope I'm making sense. Then there is a third state. I see a lot of comments on Twitter about martial law. Okay, we don't use that term really here. We have what's called a state of defense, which is even further than a state of emergency, and that is when the Republic is under threat of war or threat of some kind of physical attack from an external force, or like a threat of biological warfare or something like that. Okay, so that's a state of disaster, and that would be a total and utter military state. Okay, so there the state just says, sorry, guys, we need to protect our borders, and that's it. So there you've got significant state power, and you've got a huge limitation of rights, and Parliament's role is there, but it's a little bit compromised because the power is so concentrated in the president. So those are the three different stages. As for why the government chose a state of disaster, I think initially the reason was because you would struggle to find an argument that we needed to restore peace and order. What peace and order did we need to restore at the time? The Republic was relatively fine. I mean, aside from the fact that the economy was tanking, but that's hardly unusual. So the government would have been, I think, at that stage precluded from having done or declared a state of emergency. And I think then what happened is, you've landed up in a state of disaster, and it's just been absolute hysteria and pandemonium. And this whole thing has been extended and blown out of proportion to an extent that what's happened is I think the executive has just started to abuse its powers under the Act.
Is the new normal, that it isn't a crisis. Now, that's a very interesting line of argument that I haven't really considered much. But in terms of success in the courts, what's your prognosis?
Is this viewer talking about the Concourt DA challenge, or is he just asking generally?
I think generally.
Like I said earlier, I would hesitate to go directly to the Constitutional Court. I would go High Court and work my way up. I haven't applied my mind to that argument, but it seems to me to be a little bit too theoretical for the courts to consider. It seems to me where the courts would say, well, we're not here to give you an opinion on whether this is the new normal. And as for proving that it's the new normal, that is going to be a task that I don't think it's even possible. So my gut, I mean, I can't give you my view now, but I mean, my gut would say negligible. Yeah.
Right. Then I think I'm going to bring our hour together to a close. It did go exceedingly fast, and I think we kept. You managed to sustain the interest and keep it interesting throughout. So thank you very much for that. Perhaps a final word from you at a specific point. I always ask this to people, and it does throw them, so I apologize if this throws you. What is the one thing we should be paying attention to that no one is paying attention to currently?
Digital surveillance.
In terms of COVID-19 as well, or broader?
Yeah, I would say generally, but I think specifically, actually, there are two things we should be paying attention to. The one are the digital surveillance regs, specifically the ones that allow government to keep data after the event. That to me is beyond the scope of the act. They're only allowed to make regulations that last until the disaster is over. So there's no basis to keep that data. And I would also suggest interrogation of this concept of de-identifying data, because my friends who are involved in artificial intelligence have said to me, basically, there's no such thing. You know, you can de-identify data and then you can re-aggregate it later. You know, so I think there needs to be a lot of understanding about how that works, because there are definitely tracing moves happening. And the other thing that I would focus on is this these regulations dealing with forced treatment. I don't necessarily mind people being forced to test, etc., but I have a problem when people are forced to be treated. So, and here's an example. If I get diagnosed with COVID and I say, thanks very much, I want to go home, lock myself up, and I'll take my chances. If I die, I die. Thank you. Who are you as the state to tell me that I have to be treated? Mm-hmm. So those are two massive infringements that I feel are their face, that are just not getting attention.
Thank you very much. I didn't think about digital surveillance until you mentioned it. So that really underlines the fact that it does need a further attention. Advocate Richards, Erin-Dianne, thank you so much for your time this morning. I am going to bring today's discussion to a close, and I really appreciate everyone's time, the media who've been in attendance, as well as the YouTube audience. Thank you so much, and for the questions on YouTube, on Twitter. It really is deeply appreciated. From my side, from the Institute of Race Relations side, it is a difficult time for our country, and the points that Erin-Dianne raised deserve intense attention, and it deserves the interest of many, many South Africans. And we as the Institute of Race Relations, we are very encouraged by the reinvigoration of civil society, perhaps even the invigoration of civil society for the first time in decades. With regards to that, we will shortly be writing to the President and to the Presidency, advising them that they should tread legally carefully, that the legal arguments against their position, that these arguments are strong, are valid on the whole, in the main, with, of course, your perhaps more fanciful exceptions. But the reality is that government is facing a litigatory crisis of its own making, and the Institute of Race Relations is ready to jump into any fight and make a difference, whether it is in the role of a litigant or whether it is in the role of an amicus brief to whatever court. In that regard, we want civil society, we need civil society to step up with us, to step up with the other NGOs, Dear South Africa, Solidariteit, who have really been leading voices in this coalition fighting for liberty. Erin, you have been a significant voice in that coalition. We are really, really incredibly grateful for the work you've done, and we wish you the best of luck for the work you are still going to do.
Thank you, Herman. I greatly appreciate it, and the very same to you, and I hope that we'll stay in touch.
Likewise. I want to thank the Friends of the IRR. A final thank you to the thousands of Friends of the IRR who, through small donations, anything from 20 Rand per month, make it possible for the Institute to continue its almost a century-long fight for a better South Africa, for a liberal South Africa, where the individual, where the rights, where the freedoms that are hard-won can be protected, where liberty can be kept alive. And it is thanks to you that we can do this. All the very best, and we'll speak again.
Thank you. Cheers.